Please be seated. We'll be back on the record. Our second case today is case number 23-4087, J. Stephen Gibson versus the state of Florida. Mr. Bark, how much time would you like for rebuttal? Oh, Mr. McLean, right on.
5 minutes, Your Honor.
All right. I should recognize you, sir. I apologize for that. Okay, whenever you're ready.
May it please the court, Matthew McLean and attorney Matthew Spark on behalf of the appellant Chase Gibson. I'm hoping today that the issues that we present are a little simpler than the first case that was heard by this.
All right.
I have no envy of the corporate and trust law context. Today I like to group the issues essentially by two categories. The first one has to deal with the right to counsel and right to self-representation. And then the other two have to do more with what happened at the trial itself. Starting with the first briefed issue, Mr. Gibson, after the court conducted a Nelson inquiry, moves for a continuance so that he could retain private counsel. The defendant has a constitutional right to counsel of their choice. In the context of moving for a continuance to obtain counsel of choice, it is a balancing test the court must go ahead and use to make a determination of whether.
Why is it a balancing test?
Because the defendant has a constitutional right to counsel of choice, and the court has the right to manage their caseload. So there's a balancing between the two of those.
I guess one question is who has said it's a balancing test?
Precedent from
other DCAs?
The DCAs, correct.
Are we bound by those other DCAs?
No, Your Honor. Based on being the new Sixth District Court of Appeal,
Yeah.
you can go ahead and.
Correct. So I think there are cases in your brief that obviously clearly stand for the proposition the trial judge was required to do an inquiry, right? And variety of things, some of the DCAs state it a little differently, but it seems at least the first and the fourth have clearly said there needed to be an inquiry at which certain things were considered, then she can make a ruling, and she didn't do an inquiry, right? She just denied it. I'm thinking of it as a matter of first impression, right? We're not bound by those DCAs. I didn't see anything from the Florida Supreme Court. Why was she required to, not relying on the other DCAs? Why would that be right? That she's got to do a specific inquiry orally, right? As opposed to just read the situation herself and rule, right? I mean, because that's really the distinction. Was she required to discuss this in court before ruling? Or could she presumably consider those things in her head and rule without discussing it? The other DCAs have said there's got to be a discussion. And other than saying because other DCAs have said it, why is that correct?
Well, I'll start out with there's no DCA that I'm aware of decision that says that there's no inquiry that is not needed. So this would be, an outlier jurisdiction. So if the court does take that position, it would need to certify conflict on the issue. But as to why, I think the purpose of it is to prevent from arbitrary denial of motions to continue when there's accompanying a right to choice of counsel as well. So it's in order to actually.
Can I ask you about the first thing that you just said? Because I notice evolution in the cases. All the way up until Deal, which is the fourth DCA case, it talks about doing two separate things. It talks about making inquiry, or it talks about whether there's record support for something. And then we move on to, I'll mispronounce it, Cardozo, Balsaron. Those particular cases seem to throw out the notion of the record supporting it. Is it your contention that there always has to be an inquiry, even if the record doesn't support the need for one?
Yes, there always needs to be inquiry according to the case.
Where does that come from? So to go on Judge Mize's questions to you, as a matter of first principles, you say that, and I think there may be something to your argument, that the idea here is to safeguard the constitutional right to counsel, right?
Correct.
If the record supports that it is being done for delay, or it's frivolous, or for some ulterior motive other than to support the right of counsel, why would there need to be an inquiry in that situation? And look, I'm not touching your case for the purposes of that question. I just ask you to answer it in a legal vacuum.
I think if it's, I think all the courts, they kind of go through this analysis, even saying that there must be an inquiry, they go ahead and they follow up and say, well, in this case, it looks like there was not any sort of bad faith within the record. So the courts kind of strike a balance from there must be, and then they kind of go into Well, in this case. if we
Does
look at
it
the
matter that
circumstances-
if we were to look at whether there was support, like had there been an inquiry, the trial judge obviously could have made the same ruling, that there was a plethora, a wide amount of what looks to us like support for her ruling. She just didn't do the inquiry before making it. Is
Well,
that significant?
Well, there's three factors, right? So there's the first factor is bad faith or as a delay tactic. And so there's support from both sides that this was in good faith.
Well,
And
there's
bad
support for both sides, right? It's abuse of
Correct.
discretion. That means there's support for her ruling, right? So by saying there's support for both sides, you just conceded she could have made this ruling had she done the inquiry, right? Because if there's support for both sides, that means she can do what she wants. It's abuse of discretion,
Well,
right?
I think had she done a proper analysis, then she would have made the determination, but we don't know how she ruled on the issue because there's no recognition from the court that it was recognizing his right to counsel at the time and balancing that with this.
You're right.
case.
You're right. She didn't do the inquiry.
Correct.
I agree with you on that. I'm not disputing it. I'm just saying, does it matter if we determine that, hey, she didn't do the inquiry? Had she done the inquiry, we think there was plenty of support in the record to sustain her ruling had she just done the inquiry first. And so this isn't a case where there's a problem with the ruling itself or there wasn't support for it. It's just the fact she didn't discuss it, right? If you were to get a reversal on that issue, and if we thought there was support for her ruling, but you got a reversal anyways, you'd be getting it not because she was wrong, but just because she didn't discuss it on the record first. And I agree with you. That seems to be what the first and fourth have said. Okay. And I guess what I'm saying is, are the first and fourth right about that? Like, what is the first principles explanation for why, in order to respect his right to counsel, she had to discuss this before deciding he was doing it for improper reasons?
Well, I think if you want to protest against arbitrariness in denying motions to continue, then that's what you need to go ahead and do is you need to have an open discussion. And the case law told the court at the point in time, which she was bound by, to go ahead and do that inquiry. So I don't want to go ahead and say for this court to.
It's just policy then?
I think it's good policy. And,
Okay. Is there any, I'm not saying that's not a valid thing for you to argue, but is there any, other than policy of like, hey, we think this will facilitate discussion and protection of the right, and so it's a good rule to impose. Other than policy, is there any kind of legal first principle why we should adopt that?
I think, yeah, it also aids appellate review to determine the arbitrariness of the ruling. And when you look at the other two prongs, we're kind of been talking about the first one, is this going to prejudice the state, the continuance? There's no objection. There's no evidence at
Okay,
all.
I'm not talking about
that
whether the ruling was good or bad. I'm just talking about whether or not an inquiry had to be made before making the ruling. To me, that's the key issue there is the lack of an inquiry.
I think it's a must. It's a must. And I would go ahead and cite to all the DCAs that go ahead and say that that's at this time.
Even the ones that say that if the record has enough in it, that you don't need to do the inquiry.
Well, I don't see any decision that's been cited that hasn't resulted in reversal. So it's kind of almost dicta in a way that they're going through in this situation. This is would support a
I
good
understand
faith.
your answer. Could you move to the second issue?
Can I ask one more
Oh.
question on that? So the cases, I just want to make sure I have a comprehensive list here. The cases that you would say support your proposition that there must be inquiry anytime there's a motion to continue. I have Deal, Alvarez, Jones, Foster, Perozzo, and Valcarcel. Those were cited in your brief, I believe. Any others that you're relying on here today?
I think the other one is Madison. They take a little bit of a different approach and look at the McKay factors. But ultimately, I believe Madison also talks about that as well.
Okay. Unfamiliar with Madison, and I apologize, but at least in regards to Deal, Alvarez, Jones, Foster, Perozzo, and Valcarcel, in all of those cases, every one of them, the name of the proposed attorney was known to the court, made known to the court at the time of the motion to continue. And the attorney was either retained already or personally appeared to make that motion to continue. Do we have either of those in this case?
I would point the court to the Deal case as well. In Deal, the attorney was named, but he was not present, had not went ahead and made any sort of appearance in the case. In Deal, it was essentially the public defender telling the court that the family had indicated to the public defender that the family was looking to retain counsel. And so in this case,
Well, no, the mother actually said that she'd already retained counsel. So, and there was no question that counsel had already been retained. I mean, from a factual standpoint, the appellate court was treating that as knew the name and mother represented that the person had actually been retained. There was no question that, was the mom telling the truth.
Mhm.
So I don't think the deal falls outside of the question that I would ask you, which is, are you aware of any cases where there was a reversal on appeal on a trial day motion to continue, where there wasn't a name of the attorney mentioned and the attorney was either already retained or physically appeared in the courtroom to ask for the continuance? Are you aware of any?
Off the top of my head, of those cases that you're citing to, no.
So,
But
so,
I'll-
so then that would put us in the position as the sixth DCA, talking about first principles. We would be the only DCA to have reversed on an issue such as what you're raising here, where there was no name of an attorney mentioned and the attorney was neither retained nor personally appeared in court. Would that be correct?
I don't know if that's correct, because I don't want to go ahead and say that there's no case out there. But I would say that in these other cases that the attorneys had withdrawn at that point in time. So in a way, we have the same exact circumstance. So in Barcasel, we had a situation where they had filed an appearance.
Yes and no. Yes and no. I mean, what I'm looking at here and my challenge with this is that you've got multiple prior continuances that have happened in this case. You have an effort by a defendant to say, I want a continuance, I want to get private counsel. And then he makes this quizzical statement. I talked to this guy for 30 minutes and he fully understands my case, which I think every person on this panel would think that's a little crazy to make that sort of a representation to a court. I don't think any attorney would make that sort of a representation. And then we've got no name, no retention, no facts in the motion saying, and judge, this is how I'm going to get the funds to retain this person. Nothing, just a judge. There's this person that I spoke to on the phone and I want a continuance. He really understands my case. I don't find any cases that support that even being cognizable as a good faith motion to continue. Why should the trial court have to sit there on the record every time something like this happens and say, okay, stop the presses. Even though this is so obviously not a good faith motion, I'm going to find it's not good faith because they didn't mention the name. He hasn't given me any plan for retention. This attorney has not appeared. Why shouldn't we go that route?
Well, you're supposed to do an inquiry. So had these questions been asked and had that inquiry occurred, then maybe we'd have more understanding of what efforts were taken to retain counsel and provide names. But the court cut them off, said, no, we're ready. We want to go today. We're going today. There's no inquiry. I would point also to during the Nelson proceeding, the appointed counsel did mention that the family had reached out to him to advise him that they were in the process of retaining counsel as well. When it all comes
Which case? That wasn't this case.
that was this case.
Okay.
During the Nelson proceeding, appointed counsel mentioned that the family had contacted him basically after they had met November 10th, or not November 10th, November 1st, with Mr. Gibson, and told the attorney, can you get a continuance because we're trying to retain counsel? And the appointed counsel said, no, I'm not going to do it. So I don't think that the attorney being named when there's no sort of inquiry and no finding
It's
of
kind of like
bad
a
faith.
proffer, right? If the trial court doesn't let you, normally you got to do a proffer, but if the trial court doesn't let you do the proffer, cuts you off while you're trying to talk, you can't say you didn't preserve because you didn't do your proffer if you weren't permitted to do a proffer. If you're trying to discuss why you need a continuance and give details and the trial court cuts you off and doesn't let you give the details, you can't really say, oh, well, he didn't give details.
Exactly. And there was no recognition that he had that right. And that kind of brings us to the second point, because when you look at how this trial judge was conducting the trial, it was not to give Mr. Gibson opportunities to explain himself.
I don't want to cut you, but I want to hear from you on Fred before you run out of time. All right, so we've got this statement in Weaver. Okay, and it says, a defendant who persists in discharging competent counsel after being informed that he is not entitled to substitute counsel is presumed to be unequivocally exercising his right of self-representation. Now, it seems like your client fits within that statement. Okay, he said he wanted to fire his counsel, so he tried to discharge his counsel. And he was told previously during the Nelson hearing, I'm not letting you get other counsel. If that statement is a holding, I think you got a really strong argument. If it's dicta, I think we're not bound by it, and we're looking at this from first principles, and then it's just, we're looking at kind of general Pareto law and trying to figure out what binds us. So can you give me a Pedrosa analysis, or however you'd like to discuss it, on Weaver as to why that statement is binding on us?
Well, I'd like to, in Weaver, perhaps it is dicta, but if you look at the cases cited to by Weaver, it goes ahead and cites the other.
Are you saying you
decisions.
think the statement is dicta?
I'm saying that it could be construed as dicta in that case, but ultimately, when we look at the decision itself, it cites to other Florida Supreme Court case law, and in those cases, I think it makes it more clear that this is not a dicta statement, and that is a principle by the Florida Supreme Court. That when you make that,
All right, so if you don't think that statement is a holding, then take me through which gets, there's language in various cases that support your argument. The question is whether those are holdings or dicta. So if you're not confident Weaver is a holding, or at least the statement in it that helps you, which cases are you referring to, and which language are you saying is a holding rather than dicta? Because I think, Weaver helps you, Jones helps you, Mosley helps you, but in terms of some of the statements, but which of those statements are holdings that you think we're bound by, and why?
so I think Mosley is probably the best case for the proposition, and in Mosley, essentially there was a death penalty case, and prior to the Spencer hearing, the defendant made a similar request in the case for self-representation, and the court went ahead and found that it was error
But in
to.
that case, didn't he say, I want to represent myself?
I had to go ahead and look on rebuttal. I'll take a look at it and let you know.
Well, in Mosley, he specifically filed a motion that says, and I quote, unequivocal demand to immediately represent myself. So I would call that an unequivocal
Correct.
demand to represent himself.
Correct. That's why that statement in Weaver is so important for you, because Weaver basically says a statement like the one your client made here, even though he didn't say, I want to represent myself, constitutes an unequivocal demand. It says defendants who refuse appointed counsel but do not provide their own and are presumed to exercise the right to self-representation, even though they don't say it. So that's kind of the piece. I agree with you. If somebody makes an unequivocal demand or says, I want to represent myself, you got to have a Pareto inquiry. Your client didn't say that. And so it seems like you need some kind of holding, like the statement in Weaver, if it was a holding, saying that what your client did here puts you in the Pareto bucket.
Well, Your Honor, I'll take Weaver as the case then.
All right, well, then you got to go back to my original question. I asked you, explain to me why it's a holding, and you said, I'm not confident it's a holding.
But let me go ahead and look at it during the
Okay, why don't you do that?
rebuttal period. I'll come back to it, Your Honor. I'd just like to go ahead and briefly touch on, the third issue, because it also dovetails into his right.
So you've got 2 minutes left. Do you want to use another third issue, or do you want to?
I'll reserve it, Your Honor. Yes, thank you.
Good morning. My name is Robert Bradford, and I represent the state of Florida in this matter. I think it's important to realize, with respect to all of the first three issues, that the appellant in this case had an issue with both stand your ground law and self-defense. He seemed preoccupied with the fact that the victim's girlfriend, Mills, was the initial aggressor here. In fact, he raised that at several points throughout the trial, including at the Nelson hearing on the morning of the trial. That's one of the reasons why he felt his attorney Klein was incompetent, because he hadn't done anything to depose the witness Daniels, who apparently had some information that Mills was a fighter or had a reputation for being a fighter. But the problem with that is none of that's material. It doesn't matter if she was a fighter. It doesn't matter if she had a reputation for fighter, because there was no evidence to support that he knew of that reputation.
So can I ask you to get to the Pareto issue? So I want to ask you the same question. I think this statement in Weaver is really helpful to them and unhelpful to you. Okay. The question is whether that's a holding or dicta. Okay. If it's a holding, I think his client pretty squarely falls within it. If it's dicta, then we're not bound by it, and we're looking at this from kind of right of first principles, right? Well, that's a much more complex analysis. This statement in Weaver, a defendant who persists in discharging competent counsel after being informed that he is not entitled to substitute counsel, is presumed to be unequivocally exercising his right of self-representation. He did that, right? He said, I want to fire my lawyer. So he tried to discharge competent counsel, and he had been informed he wasn't going to get another lawyer previously. So I don't see how he doesn't fall within that statement. Tell me why that statement, from your perspective, if you think I'm wrong as to whether he falls into it, feel free to tell me that and explain why. If you think I'm right that he falls within that statement, tell me why it's dicta as to Weaver and we're not bound by it.
First of all, I don't think it's the holding of the case. I unfortunately cannot tell you as I stand here today why it's not the holding of the case.
Then other than it being bad for you that it's the holding, if you can't tell me why do you think it's not the holding? Is it just because if you give that answer, you think you lose?
No, first of all, I think that's, and this kind of has to go back with the first issue on the continuance, is we're debating a couple of issues today and whether to elevate form over substance. And we shouldn't do that because, I mean, that's almost like a return to code pleading. With respect to the continuance, if the record is clear.
Stay on my question. I'm a Freda and Weaver. Give me whatever you can, the best that you're prepared to give as to why that statement is not binding on us, why it's not a holding that we are required to follow. Or if you think I'm wrong that he falls within the statement, you can explain that too, but stay on that issue.
I don't think, as I recall reading that case, I don't recall that was the operative mechanism to resolve the case. It wasn't the holding of the case.
And counsel, in Weaver, did the trial court tell the defendant expressly, if you proceed with discharging your attorney, you will go forward pro se without an attorney? Was that actually told to the defendant in Weaver?
As I stand.
And if you're
today, Your Honor,
confused, the answer is yes.
I
The
would
trial
think-
court did tell that to the defendant in Weaver. And my question to you is, did the trial court tell that to the defendant here? Did the trial court expressly tell the defendant Gibson that if he fired his attorney during the Nelson hearing, did the trial court say, if you do this, you will be proceeding pro se?
No. The
Okay.
trial court did not.
So does that then distinguish us from Weaver?
There is a factual distinguishment in that sense, Your Honor. I also would offer to the court that this whole entire issue was not properly preserved for appellate review. Under the Rutledge case from the first DCA, and I cited that case in my brief for the purpose of the fact that it can be harmless error when that advisement, that notification is not given. But the Rutledge case on page 1126 talks about the fact that in that case, the state had correctly argued that the appellant in that case had to prove fundamental error because they did not preserve they did not make an objection at trial in the circuit court and give the circuit court judge an opportunity to rule on them and to correct its own mistake in the first place.
I don't understand lack of preservation. He said, I want to fire my lawyer. I mean,
He never said that.
Yeah, he did. He said, I want to fire my lawyer.
Oh, I'm sorry. Yes. He said he wanted to fire his lawyer. He never said he wanted to represent himself.
Well, but that's the whole point. That statement in Weaver says he doesn't have to say that. It says defendants who without good cause refuse appointed counsel. I'm sorry. A defendant who persists in discharging competent counsel, right? Which is what he did. He said, I want to fire my lawyer. After being informed that he is not entitled as a substitute counsel, is presumed to be unequivocally exercising his right of self-representation. So that's my whole point. That statement in Weaver seems to say he doesn't have to say, I want to represent myself.
If the court focuses on individual trees, we're going to get bogged down in some.
Counsel, this isn't trees. This is this a holding? There's a mechanism to.
That's what I'm trying to explain to the court. There's an overall arcing of the facts in this case where appellant had hired his own attorney, Attorney Mills. Attorney Mills worked 2 years, not a peep out of him with respect to dissatisfaction. He worked for 2 years. He filed the stand ground immunity motion. He didn't get that right because the appellant was afraid of admitting that he actually killed the person.
Counsel, you're giving me an
So-
analysis of this case, and that's important. But what I need is an analysis of Weaver. I need to know whether that statement is a holding. The Supreme Court has set forth a mechanism for telling us what the holding of cases in. It's set forth in Pedroza.
Do you stand by your earlier answer that you're not prepared to do that today?
I don't have anything else to address that with respect to the holding in specific, other than the factual distinction between the two cases. And the fact that this one is not preserved, and the fact that the Rutledge case can say it's harmless error. If it can be harmless error, then it can't be a holding that says you have to do it in every case, and every time it's not done, it's reversible error. It can't be. It doesn't work that way. The Rutledge case, they found harmless error because Rutledge had never challenged the denial of his discharge motion after following the Nelson hearing. And he never actually requested to represent himself. That was the harmless error that the Rutledge court found. That's exactly what we have in this case. He never said, I want to represent myself. He clearly, throughout 3.25 years of litigation, said, I need an attorney. He had one, Cashman, appointed. She worked for 90 hours, got a bunch of preliminary stuff done. He then goes out and hires one. For 2 years, they prepare this defense, this strategy. They lose the immunity hearing. Now I'm not satisfied with this attorney. So he had 3 months to hire another one, didn't choose to do so. Lets the court appoint Attorney Klein. Attorney Klein comes in, and by the time 7 months later, he still hadn't said anything. A week before trial, he writes a letter and says, I need, this attorney is incompetent. I need a new one. It's a theme. It supports the bad delay or bad faith and delay tactic conclusion, not that the trial court made, but certainly is there supported by the record evidence. And with respect to not being told that you have the right to appear pro, or you might have to appear pro se if you discharge this counsel, he never asked to do that. He never asked. In fact, he had just had a Nelson hearing seeking to discharge this attorney, and he said, all I need is 30 days, Your Honor. Give me 30 days continuance. I'll get another attorney. I've already talked to him. He never at any time said, I want to represent myself. So if this court imposes an obligation on all the circuit courts in this district to then have a formal inquiry or be prepared to lose every ruling if it misses this case.
To me, the question is whether the Supreme Court has already imposed that, right? And whether we're bound by it. And it's kind of, there was a, this case was in the briefing, and it's a Supreme Court case that's kind of directly relevant. So for you to come here and just say you're not prepared to discuss, it's really not very helpful, right? It's not like it came out of nowhere. The case was central in the briefing, and it's a Florida Supreme Court case right on this issue. I'm looking at Weaver, and in Weaver, the issue was whether the trial court properly gave the Friday inquiry, right? The court gave the Friday inquiry, and he argued there shouldn't have been a Friday inquiry. And so the Supreme Court had to look whether or not it was proper to give a Feretta inquiry, and found that based on what had transpired in that case, the fact that he tried to fire his counsel after being informed he wasn't going to give new counsel, that he had made a request for self-representation, and therefore the Feretta inquiry was proper. That seems to me to put that statement in the line of decision that was critical to the judgment, right? And that's kind of the test we use under Pedroza for whether something is a holding. And so, I'm interested if I'm wrong about that, but we've got a Florida Supreme Court case in the briefing, like directly relevant to the central points in the case, and you come to oral arguments, I'm not prepared to discuss it.
Your Honor, he didn't ask to represent himself. He had just asked, he just told the court he has another attorney he's already talked to. He wasn't asking to represent himself. The Florida Supreme Court, I don't believe in Weaver, imposed that line in the sand. I don't think they drew a line in the sand and said in every case, you have to say this, and if you don't say it, it's reversible error. You lose the convictions. Attorney Klein, one of the complaints that the appellant had in this is that Klein had no strategy. And Klein told him that the appellant was afraid of going to trial. This was the third time he'd shot somebody and had to go to trial for it. He was afraid of the surveillance video. The surveillance video is clear.
Counsel, let me ask you a question.
Yes.
Are you aware of any case where a person said, I want to fire my lawyer mid-trial, and the conviction was overturned because of a failure to conduct a Ferretta hearing?
Requests made during trial are untimely. I know no such case. With respect to going back to the continuance, in addition to the bad faith, what I've tried to paint a picture is that the record does support the fact that there was no reason to have a continuance. He was making a bad faith continuance request. He was.
Counsel, say I agree with you completely that there was ample evidence to support the trial court's ruling. I'm concerned that the first and the fourth have said there needs to be an inquiry before that ruling is made. Okay, that seems to me to be what they've held. If we agree with you, even if we think there was tons of evidence to support the trial court's ruling, if we say that it was okay for there to not be an inquiry before she made that ruling, are we not in conflict with the first and the fourth? Which I'm not saying we can't be in conflict, but I'm just saying, do we need a certified conflict in order to agree with you on that issue?
No, the holdings of those cases, those are not the holdings of those cases. They may have found an abuse of discretion in those cases, but they didn't say that the failure to make those findings or the failure to have such an inquiry is an abuse of discretion.
So I've got
What the
from
Madison court
fourth,
said.
hold on, I've got from the fourth, any denial of an accused request for a continuance to retain counsel of choice must be based on an adequate inquiry into the surrounding circumstances and proper findings. So the fourth, that's the fourth, that's the deal, has said there's got to be not just an inquiry, but findings. I mean, I'm seeing Foster says the same thing, right? Was
Yes,
the trial court made no such determination, right? The court didn't examine it. We've got Madison, where the court said, here's all the factors that have to be considered. So I'm not saying what in terms of the merits of decision, I could totally see your argument as to why there was ample evidence to support the trial court's decision.
Your Honor,
I'm just saying, are we not dealing with the first and the fourth, saying that there had to be some inquiry before she made that holding or that decision?
the Madison court, which is a fourth PCA case, Your Honor, said that the order denying a continuance without such an inquiry is more subject to reversal. Not subject to reversal, more subject to reversal. That suggests to me that it's not 100% of the time. The Valcarcel, apologize for my pronunciation, said not every request to substitute counsel on the eve of trial may be denied without an inquiry. That tells me some can. If they said it's one way or the other, this language would not be in the opinion. And the Perozzo opinion, I think, while it does talk about how important it is, it goes back to the purpose for such an inquiry, and that is to determine whether the continuance denial was arbitrarily imposed. In this particular case, it clearly was not. He had fired or tried to fire every attorney that didn't implement his defense strategy that he wanted to implement. He did it to Mills after he lost the immunity hearing. He tried to do it to Klein after Klein tried to bring out Christina Mills was a fighter in the trial. Objection, proffer. Comes back in, I want to fire my lawyer. Don't say that again. I want to fire my lawyer. It's a delay tactic. It's bad faith. I think it's very clear that the court is not required to elevate form over substance. And that's what appellant is asking this court to recommend. With respect to the stand your ground hearing testimony from Ms. Mills, I'm pretty sure Ms. Mills was not called to trial because she made a terrible witness. If you look at the video, she pretty clearly is instigating this. In the video, there's a line of parked cars, an open area. Victim and Ms. Mills come out and get in their car very clearly on the camera. Victim comes in, appellant comes in, parks his SUV. There's plenty of room for them to get out. In fact, they do. They do pull out. They have to stop because there's people walking around getting their cars. And after they sit there for a minute, Ms. Mills gets out of the car, goes back, starts saying something to the appellant, and It's obviously words are said back and forth. And then when somebody walked, it would appear to me that there's some elevation in the tone or the volume, because then people start coming in and somebody even walks up to her, and about the time they walk up to her, that's when she goes after him. But he pushes her back. So she clearly is the initial aggressor. But I don't know of any case or any aspect of Florida jurisprudence that said because a girlfriend takes a swing at you, you get to shoot her boyfriend in the face. Her unarmed boyfriend. Now, appellant and the victim about the same height. With respect to her testimony, with respect to her testimony, it's not material. It's not material to the elements of the charges. It's not material to the defense. She's clearly over here in the video. The victim's over here. Appellant is standing in between, beside his car with the door open after he retrieved his firearm. He's going with no shirt on. He comes around the door, at least past one person, possibly two. You never see his arm up like this, where he says he brought it down and tried to hit him over the head and gun it off. What I saw is a punch. Now, he may have tried to punch him with a gun, or he may have just tried to shoot him. I don't know. It's very quick, very happy. But her testimony is not material to any aspect of this case. So he couldn't have read that testimony into the record. It would only have done one of two things. It would have supported the video evidence, which, so therefore its conclusion is not prejudicial. Or it would have conflicted, and they would have been admitting the testimony, basically calling the witness to impeach her, and that's not proper. This would be testimony that she's a drinker and a troublemaker, and it's improper character evidence, and it's not admissible. And again, even if it was any error excluding it would be harmless because of the fact that it had no materiality whatsoever. The last issue also was not preserved for review. They failed to give the proper instruction. Just with respect to that, I'll say that the instruction that was given did not misstate the elements of any offense. It did not misstate the burden of proof. If I am correct, I believe they gave the old instruction that was then later modified. Not that it was incorrect, but that the Supreme Court just found a better way of saying it. As far as the burden of proof, they've said that the justifiable use of deadly force is not a crime. The state has the burden of proving the crime, and the defendant didn't have the burden of proving anything. So with that, I would ask the court, unless you have any more questions, I would ask the court to affirm in all respects. Thank you. Thank you.
May it please the court. Going to Judge Myers, your point. So in Pedroza, in order to determine whether reasoning is dicta, you look at one, are actually decided, two are based on the facts of the case, and three leads to the judgment. So I think Weaver is not dicta. When we look at Weaver, as your honor recited, it was determining whether a FREDA inquiry was correctly done in the case.
And counsel, let's say I agree with you, but it's not dicta. But let's look at the sentence itself in context, because I think context is important here. The specific sentence in Weaver says, a defendant who persists in discharging competent counsel after being informed that he is not entitled to substitute counsel is presumed to be unequivocally exercising his right of self-representation. That's the particular quote. The facts of the case that the court had just clearly recited were that he was told, if you proceed with firing your lawyer, you will be going pro se, sir. Do you understand that? Don't you think that what the court was really saying was, in shorthand, after being informed he's not entitled to substitute counsel, wasn't that just shorthand of the court saying he had a mentality of knowing he was going forward unrepresented from that point?
Yeah, I mean, absolutely.
And if that's the case, if that's what the court's saying, that he was going forward unrepresented, in this case, in Gibson, was Mr. Gibson ever told he was going to go forward unrepresented if he fired his attorney?
Explicitly, no. But
all right. So let's say that he was not explicitly told that. So then doesn't that take us outside of the holding of Weaver?
No, it doesn't, because he was essentially told that. When you look at what happened in the case, I want a new appointed counsel. No, you're not going to get that. I want a continuance to retain private
No,
counsel.
but
No, you're
the
not.
court specifically said, no, you're not going to get that. You're going forward with this lawyer. That's not what happened in Weaver, right? The court said, if you fire this guy, you're not going forward with no lawyer, you're going forward pro se. The court in this case said, you're going forward with this lawyer, your lawyer, the person sitting right next to you.
Well, I think when he's making that request, I want to fire my attorney. That's the only option that was available to him, is to go self-represented. And there was no inquiry done. She cut him off. She said, if you say another word, I'm going to go ahead and make sure that you can't. So when we look at what happened in this case, although it wasn't explicitly, that was certainly implicitly. And if the court does go on that line, that points us to the third issue, where the Nelson requires the court to go ahead and say, I'm not going to discharge counsel. And if you do so, one will not be appointed to you.
Required to say that, right? The court should have said that under the Nelson case law, with the exception of Rutledge. So we get to the Rutledge case, and in the Rutledge case, the court was faced with exactly that scenario where there was a request to discharge an attorney. The defendant was not told that he was going to be going forward with self-representation if he discharged the attorney. And in Rutledge, the court said, the state convincingly asserts that any error in the failure to advise is harmless beyond a reasonable doubt, given the facts that appellant did not challenge the finding of effective representation and never expressed a desire to represent himself. Isn't that exactly what we have here? He has not challenged on appeal the effectiveness of his representation, and there was never an expressed desire for him to represent himself.
I don't think it's talking about, can I respond, please, Your Honor? I know that I'm out of time.
Oh, of course, yeah.
So I don't think it's, did you argue on appeal, but did he argue that he wanted different counsel, was dissatisfied with counsel at the relevant period of time?
Not dissatisfied, ineffective.
Yeah.
I mean, it specifically says you got to challenge the finding of effective representation. The Nelson finding of effective representation has not been challenged, right?
I think
Hasn't been challenged.
Mr. Gibson challenged his representation throughout the entirety of the proceeding. Immediately upon Nelson.
It's the finding of effective counsel.
Correct.
The court says you have to challenge.
Judge Smith is saying you didn't challenge it on appeal. You don't assert on appeal that his counsel was ineffective. You assert he thought his counsel was ineffective at the trial level, and that Nelson inquiry wasn't done properly. But you don't challenge on appeal the fact that the trial court's finding that the lawyer was in fact effective.
Well, we can't bring that up on appeal because it's prohibited by the Florida Supreme Court. So, but certainly, he showed dissatisfaction immediately upon.
So did Rutledge, though. Rutledge did the same thing. He filed a Nelson motion and tried to get his counsel discharged, and the court said no. That's why I'm saying Rutledge. We have the exact same facts. We have a defendant who said, "I don't like my attorney. I think he's ineffective," and the court said, "No, you're wrong." Just like with Mr. Gibson. So that's all. But it's all been there. But then the court throws this sentence in there that says, "Given the fact that appellant did not challenge the finding of effective counsel," so just doing the Nelson, "I don't like my counsel," obviously was not what the court was talking about when it says the appellant did not challenge, and it uses the word appellant.
So I think that our case is different than Rutledge, because in Rutledge, there was no indication from the decision that after that was done and the second part of Nelson wasn't complied with, there was no assertion by that defendant in Rutledge that his attorney, he went to go ahead and seek to discharge him later on, or he tried to go ahead and become self-represented. And so that's where it becomes, harmful in this case. It's because Mr. Gibson did those things. He did show that he was dissatisfied with his attorney throughout the trial, and he had legitimate concerns. And that, I can go ahead and go into that further, but his concerns were legitimate throughout trial. Defense counsel did not move for the blood alcohol content level of the victim in the case to be admitted. This is a self-defense case. If someone is drunk and belligerent, you don't think the jury should know that they're drunk and belligerent when you're trying to deal with that person. When you're looking at Mills's testimony, of course you want to introduce that into the evidence, because there was no other evidence as alcohol consumption in the case based off of it. And the reason why it wasn't introduced is because defense counsel thought, I can't do it. And that was it's plainly wrong. Even the state hasn't argued that he wasn't wrong on that. So at the end of the day, all these issues with right to counsel, self-representation are per se prejudicial and mandate this court reverse for a new trial, regardless of what happened at the trial itself. So we'd ask for the court to grant a new trial in this case.
Good. All right, thank you.
Thank you.
Thank you both for your presentation. We'll take the case under advisement. We'll be in recess.